You want more bunny stitch?
No, I'm trying to,
Diet?
yeah,
You feel dieting? What's that for?
I'm trying. I'm trying to do it.
I'm trying to.
Are they on bond?
You can just. I just wanted to make sure that's a fair.
Okay.
You guys bringing everybody that's downstairs.
And we have no one else signed in, so we're just waiting for their comments.
Okay.
I think it's crying and it's becoming.
Okay, and the party is on Vaquera.
Your Honor,
I'm just waiting for Hagen to come up, I guess.
right, yes, Mr. Hagan was coming in, then we'll be ready.
And we have two tweets, Rick. They're both in jail.
Okay.
Awesome.
You guys want to come up?
Yes.
Nobody's
You wanna
got
do
it.
it? Back there, yeah. How many copies do you have?
Three.
Three. Yes, please.
Three copies.
Or,
Thank you.
yes, sure.
Three, please. Thank you.
Did you not? Oh, this is it.
Thanks, sir. Appreciate the same.
Is it a person in precedent?
All right, and who is here on call Robinson? Anyone present?
He was here, he stepped out.
All right, who is here who has a client in the box and you all are ready? Or anybody who's ready? Yes, who's your client? Are they ready?
Yes, sir.
I have everything, Judge.
All right, could I have it, please?
So this is the first one given,
Mhm.
and then this is Mr. Gibbons as well, that's the second charge.
All right, Christopher Charles Givens.
Thank you.
And are there any applications?
I did not see any, Judge, but everything should be,
Should be an application
There
for
should be.
probation on both.
okay. I gave you everything I have, Judge.
Ready to fill out two more, Your Honor?
No, it's fine.
It was. May I have these right here?
All right, probation. I'm being told that these are applications.
Thank you, Judge.
Court is calling 2026 CR 0000659 and 2026 CR 0000637. State versus Christopher Givens. Can I have parties announced?
Sworn affidavit for the state.
And Eric DeWalt, and I represent Mr. Givens, and for the record, I would like to say one thing. His name? Brian. Your Honor, on the discovery acknowledgement, I
Mhm.
believe there's Brian Givens placed on there. We drew a line and corrected it. That's his brother, and I talked to the state about it, so all of them should say Christopher Givens.
Okay. Let me just one second. All right, counsel, in each of the cause numbers, have you received all discovery and did you review it with your client?
I have, and I believe we have, and yes, Your Honor, evidence by myself.
In each cause number, the court will find that the state is in compliance with discovery. And counsel, in each of these cause numbers, was it an application for regular probation?
Straight probation, Your Honor, yes.
All right, and each cause number, did you review the documents entitled application for community supervision with your attorney? Did you understand it and sign it? And each cause number, did you review the true bill of indictment with your attorney? Did you understand it? Counsel, in each cause number, do you waive the reading of the indictment?
I do, Your Honor.
State in each cause number, are you proceeding on the indictment as presented?
In the cause number ending in 659, state waived count 1 and proceed fully on count 2.
No objection, Your Honor.
Mr. Givens, in each cause number, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
And the cause number ending in 37, you're charged with unlawful possession of a firearm by a felon. Range of punishment is anywhere from 2 to 10 years in the prison and up to a $10,000 fine. And the cause number ending in 59, you're charged with possession of controlled substance, penalty group 1, 4 to 200 grams as a second degree felony. Range of punishment is anywhere from 2 to 20 years in the prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering these pleas, you're giving up those rights. Did you intend to give up those rights and enter into a plea in each of these cause numbers? Counsel, in each cause number, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Givens, in each cause number, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea?
No one.
Are you satisfied with the way you've been represented? If you're not a U.S. citizen by entering these pleas, you will be deported, denied naturalization, and reentry. Did you understand? In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand it? According to your pleas, punishment is to be assessed at 5 years in the prison. There's $1,000 fine probated. The cases will run concurrently. And the cause number ending in 5-9, the state is proceeding on count 2 only. And there's the restitution of $65 to the Bear County Crime Lab for drug testing. Did you understand that to be your plea?
Yes, ma'am.
Defense and state?
Yes, Judge.
In each cause number, did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community service restitution be for a term of 5 years. There be a TAP evaluation, 150 hours community service restitution, the DOEP course, MRT, zero tolerance on firearm possession. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? In each cause number, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Your Honor, state offer states exhibit 1 in all attachments in both causes.
No objections to submit, Your Honor.
All right. State, you may be excused. In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes,
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Each cause number, the court will find you guilty. Are you proceeding with sentencing?
Please, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, I've spoken to my client many times about this incident case, and I've also spoken with his wife. They were in some financial difficulties. We talked about bond reductions. I was appointed 217 days ago, and he's been incarcerated since then. I know his mind is on the right spot. We would ask that you follow the state's recommendation, please. I believe this is the last time we'll see Mr. Givens in front of you until we close this out, hopefully.
All right, do you have any children? And the home that you're living in, who lives there?
Just my wife.
All right, any children in that home?
Her kids are grown.
Okay. How far did you go in school? All right. And the cause number ending in 59, the court is, and count 2 is going to sentence you to 5 years in the prison, suspended and probated for 5 years. There's $1,000 fine that will be probated. Proof of employment within 45 days of release. No employment as a home health care provider or with minors. No unsupervised contact with minors. No residing in homes with minors. I should say households with minors. Regular reporting by Zoom or in person. Regular random UAs. $65 restitution to the Bear County Crime Lab for testing. 150 hours community service restitution. I'm going to order the MRT. Once the MRT is completed, 50 hours of the community service hours will be deemed satisfied.
Thank you, Your Honor.
I'm going to order the DOP. And once the DOEP is completed, 50 hours of community service hours will be deemed satisfied.
Yeah.
The remaining community service hours will, the court will deduct 1 hour for every sober support meeting that's completed. There's to be a TAP evaluation out of custody, follow results. If TAP recommends inpatient treatment, we'll start with outpatient treatment. There's to be field visits 1 time per month for 6 months. And this is a felony conviction, so you're not allowed to own or possess any weapons. You understand? And I'm also going to order no ammunition possession as well. Probation, is there anything else?
Okay.
Is there anything else that you need from the court to be successful under that cause number?
No.
And that cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question what that is, you'll need to speak to an attorney. You understand?
Yes.
All right, and I'm so sorry. This is going to run concurrent
Thank you, Your Honor, for that.
with 2026 CR 0003, I'm sorry, 000637.
Thank you, Your Honor.
You're welcome. All right, next, we're going to proceed in cause number 2026 CR 000637. And that cause number, as previously stated, the court is finding you guilty. Court is going to sentence you to 5 years in the prisons, suspended and probated for 5 years, $1,000 fine probated, proof of employment within 45 days of release, no employment as a home health care provider or with minors, no unsupervised contact with minors, no residing in households with minors, regular reporting by Zoom or in person, regular random UAs, 150 hours community service restitution, minus 50 hours for the MRT, minus 50 hours for the DOEP, minus 1 hour for every completion of sober support meetings, TAP evaluation out of custody, follow results. Field visits 1 time per month for 6 months, no possession of firearms or ammunition. This will run concurrent with 2026 CR 000 659. All right, is there anything else with regards to sentencing in that cost number?
No, Your Honor.
Probation, anything else with regards to that sentencing? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing. You're gonna have to start making better decisions. Otherwise, you're gonna end up spending the rest of your life in prison. And after you reach 29 and you hit 30, time just flies by. You understand?
Yes, ma'am.
All right, good luck to you.
Be excused.
Yes.
Thank you very much for
You're welcome.
consideration.
Just a moment. Oh, yes.
Just put the order for the fair case used.
All right, thank you.
You're welcome.
If I don't put something in there while it's on my mind, it's like not gonna get put in the system.
I understand.
All right,
Thank you, Judge.
you're welcome. Who's here? Carl Michael Robinson.
Your Honor.
Hello, Judge.
Hello.
Yes. Of course. You get one copy.
All right. And we're here for sentencing,
We are, Your Honor.
and are both parties prepared to proceed on sentencing?
Yes.
All right, the court is calling 2025 CR 012572-02 State versus Carl Michael Robinson. Can I have parties announced for the record?
Those are for the state.
Michael DeLeon for Mr. Robinson.
And are you Mr. Robinson?
I am.
All right, you entered a plea to count 1 on March 16th to robbery of no contest. The court found there was sufficient evidence to find you guilty. I believe you applied for deferred
We
adjudication.
did, Your Honor.
So the court deferred finding of guilt. According to your plea, the state is proceeding on the less included offense of robbery. They're asking that your punishment be assessed at a cap of 6 years. Have both parties had a chance to review the PSI report?
We have, Your Honor.
Any objections from the state or the defense?
Judge, we do have an objection,
Mhm.
and I'll do it in the form of an oral motion in limine.
Okay.
My client has expressed how, in the, pretrial report, it states about a bunch of pending charges in Arkansas, Kentucky, no, so Kansas and Oklahoma. None of those have been adjudicated. He doesn't want those cases to be held against him. Obviously, the court knows that he is innocent unless he's proven guilty beyond a reasonable doubt. So kind of like, he expressed it as a motion in limine. We'd ask that the court not hold cases that have not been adjudicated against Mr. Robinson for the purposes of this sentencing.
All right, any objection to the court reviewing the PSI report so I can review what defense counsel is referring to?
No objection.
No objection.
All right, none of these, I mean, the cases that have disposition unknown, I mean, the court is not going to consider that. I have nothing considering. That's from page 4. Now, from page 5, they have charges, driving while license suspended or suspended license, it says, and it says failure to appear.
And the reason for those failure to appears that appear in the PSI, Your Honor, is because that he's been incarcerated for the past year. So
Okay,
he probably missed a court date.
So has he been here since May 20th
How long you been in custody? Since when?
That,
of 2025?
that, August 2025.
Roughly approximately August 2025, Your Honor, so there might have been opportunities for him to miss his court date because he was incarcerated.
And he say August
Yes.
2025?
Correct.
All right, so the driving while license suspended, I'm assuming the dates to the left of the charge is the alleged offense date. So that's May. And then the date that says June 17th, 2025. Is that the appearance date? The date he was supposed to appear in Arkansas?
That's the whole issue, Judge. We have no idea how the Arkansas courts or Oklahoma courts or Kansas courts, how they do their docket and how they report things to NCIC. So regardless, Judge, because he has no convictions or any adjudications on those cases, we're just asking the court not to consider those for the purpose of this hearing.
I mean, I can understand not considering the case because no one knows. There's been no disposition on those cases. But are you saying the same as it relates to his failure to appear? Because they're saying a warrant was issued because he didn't appear.
We don't know for sure, Judge, but I think there could be warrants issued only because he's been incarcerated here for the past 7-8 months.
All right, on the dates on here, it says, and I'm taking the latest date, so I'm moving that in your favor. It has June 17th, 2025, and July 18th, 2025, and July 9th, 2025. So was he in custody in Bear County during those days?
No, Judge, he was not in custody until August 9th, 2025, and he also self-reported that was when he came to Bear County as well, and yes.
Okay, and then there's Garland County, Arkansas. There is a failure to appear for June 12th, 2025. And then it appears that they filed a felony failure to appear. That one I'm not going to consider because that is 10/14/2025. And then the Cleveland, Oklahoma, there is no disposition listed, so I'm not going to consider that.
Okay.
All right, anything else?
Nothing else, Judge. We're ready to proceed.
All right, state, do you have any witnesses?
No, Judge, yes, sir.
Defense, any witnesses?
Judge, I do have 2 witnesses, Miss Robinson, his mother, and then Mr. Robinson himself.
All right. If you'll call them up.
Miss Robinson, come on up.
Hello, good afternoon.
How are you?
Great. Could you
My
raise,
last name is O'Connor, just so. you know.
O'Connor?
Yeah, I
Okay.
just.
No, I appreciate that. Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand if you'll state your name for the record.
Jenny Michelle O'Connor.
All right, thank you. And if you'll, I know people want to face me when they're speaking, but the court reporter is taking down the record, and I promise I'll hear you, and I won't take it as a sign of disrespect.
Okay.
It will just make it easier for her.
May I proceed, Your Honor?
Yes.
Ma'am, Miss O'Connor.
Yes.
Who's Carl Robinson?
That is my son.
Okay, it's your biological son, correct?
Correct.
Okay, and how old is he approximately?
21.
Okay. He is here today for sentencing on a robbery charge. You've heard the cap of 6. And I've explained to you the possibility that the judge could give probation in this particular case, correct?
Yes, sir.
Okay, and I want to talk a little bit about Carl's background. Can you explain, number one, he graduated from high school, correct?
Correct.
You consider him a very intelligent person.
He's incredibly smart.
Okay, and can you explain to the judge his upbringing? And has he had an easy life, or what kind of life has he had?
I mean, it's been a little unfair, like just the amount of trauma that he had to start off his life with, like from the age of 2 to like 10. And then just like having to grow from that, and then unfortunately other things happened in life, and like just knowing like the anatomy of like your body and stuff like that, and how your brain is like when you already have that level of trauma, just to be able to like your frontal lobe where you're reason and your behavior and all that is naturally developed, and your body is just not developed. And I think he's just, those things have really played a great impact of poor choices that he has made, not to justify any of his behavior.
Can you explain to the court you're talking about trauma he's had through his childhood? Can you give us a concrete example of what we're talking about?
Well, my mom started molesting him when he was
you go,
like
Michael.
2 years old. And I didn't find out until he was like 10. And then my daughter's dad apparently did the same thing to him, and the situation got bad between us, and I'm alive today because my son like literally saved my life.
If the judge were to place it on deferred adjudication, do you think that you yourself could help him meet the requirements that probation would require?
Absolutely, like, absolutely,
Would he have a place to live with you or?
of course.
Okay, and you were here in court all morning, correct?
Yes, sir.
There was a co-defendant in this case, a woman by the last name of Santiago,
Yes, sir.
and she received deferred adjudication in this particular case, correct?
Correct. And that is the mother of his 2 children that are underneath the age of 2.
And she and Carl have 2 children together.
Correct.
Approximately how old are the children?
18 and 1 month. 18 months and 1 month.
Okay. And have you discussed with your son Carl about the possibilities of him being on probation and to actually, get his life together?
Oh, absolutely. And the kids and the kids are a driving force of his recognition of like how his actions are really negatively affecting people's lives that he should be there for.
And do you feel that Carl would be take on his parental responsibilities and
Absolutely.
everything he has to do?
We have 100% discussed that, and we have 100% said that we would love to have 50-50 custody between Akira and Carl.
Okay. Have the courts figured anything about custody yet?
No, Akira is being very hard to work with on this instance.
Anything else you want the judge to know about Carl and his about himself?
He's an incredibly smart young man, and he is only 21 years old, and putting such a long sentence on him really has a negative outlook statistically in life, and I just want my son to have a future.
Okay, I'll pass the witness.
So Connor, my name is Lauren Espinoza and I'm one of the attorneys for the state. Okay, I'm gonna ask you a few questions, just answer to the best of your ability. So my first question is, prior to Mr. Robinson living with you in San Antonio, where did he live?
He was in Arkansas.
Okay, do you know who he was living with in April?
He was living with Akira. They were, unfortunately, the 2 of them they chose to live in a car together. Both
Okay.
Akira, whatever.
Okay, so when he moved to San Antonio, where did he reside?
He originally came to my house. However, Akira tried to show up, and she has stolen from me before and done stuff. And so I told her she wasn't welcomed in the house. And so the 2 of them then went off together.
Do you know where they went?
No, they would sporadically call me and just, cause I worry, so they would sporadically call me and just let me know that they were like alive and okay. And I just knew they was like around abouts in the area.
Okay, so is it a fair statement that you are not fond of Miss Sun?
I would not say that, no. I mean, I believe these are both young children who have both had their own sets of issues in life and that are trying to figure out how to navigate. Akira is a young mother of 2 young children, and that's incredibly hard to deal with. And she hasn't been successful with completing her GED or anything like that, so she had, like, all that puts hardships and being able to find jobs because you're limited on pay and, like, so there's just a lot of hardships that these young children are unfortunately have to overcome.
And do you know your son to own a firearm?
No, I don't really approve of firearms.
That wasn't my question. Do you know of him to own one?
No,
So it's your testimony that your son did not possess a firearm.
I am not sure how this is relevant. Well, okay, I don't know. I don't go through my son. I don't search him. So I
Because
didn't,
he's an adult, right?
right,
And you give him discretion.
well, yeah.
Okay. So would it surprise you to learn that your son did possess a firearm?
I mean, I've
August
already,
9th?
remember, I've seen this case was not exactly is on the news. I mean, people in Arkansas heard this case,
Well, that wasn't my question.
so, I mean, it was in the report, so I knew that at that time.
But so you're aware that it's alleged he possessed a firearm?
Well, yeah, it was in the reports
Okay.
at the paper.
And that was on August 9th, correct?
If, I don't exactly remember, I have a lot going on in my life.
Yeah, okay. You have a lot going on, but you believe that this
I'm
court,
sorry. Okay,
you have a lot going on,
Mhm.
yes. And you want this court to believe that Mr. Robinson will be set up for success, right?
yeah, I'm completing at this time, I'm in nursing school right now, I have a 3.7 GPA, like, I'm changing my life and doing a lot of things, so yeah, unfortunately, I do have a life of my own that I have to monitor. That is correct, but however, if my son gets released, if that's what you're asking, will I make sure that he is making better choices and that he's not out carrying firearms and doing inappropriate things? Yes, ma'am.
And how are you going to do that?
I'm going to, as best as you can, you are not in control of anybody else's actions. You're only in control of yourself. You can only lead somebody and guide somebody. It's not up to me to make those decisions. It's up to him. How do I believe that this is different and he's doing better? I talk to him twice a week, every single week, since he's at, like, Bear County is so kind to let you have 2 free phone calls. I appreciate. And we talk in those times and we talk about things. And I do believe there's a thing called jail talk, and I've heard it all before, but I know there is a difference in his whole entire thought process. There's understanding of what he's done.
And you're aware that Mr. Robinson was also an alleged suspect in an incident of the same circumstances that occurred 7 days prior to this present instance, right?
I no, I'm not, but I also believe there's also other details of the case that you're not in highlighting. So if you want to, like, you have to highlight the whole entire thing and not look at one pinpoint, like, is your character witness, is he really a liable source? Or was he actually
That's
committing
not
a
what I
time?
asked in subcon.
No, but that's what I'm
So
saying.
let's move along.
Right, that's what I'm saying.
So your son has 2 children, right? That's what you told this court.
Yes, ma'am.
Yeah. And you testified that his children are a driving force, correct?
Yes,
And that it is these children that Mr. Robinson is realizing his actions affect lives of others, right?
his children and his family. And I have a daughter who he's very, very close with.
Right,
So, and she lives out here, so
right.
it's,
So that is your testimony, right? I don't want to mischaracterize it. Right,
Okay.
so that's what you told this court. So where was the 18-month-old on the offense date, August 9th, 2025?
the 18-month-old was actually in Arkansas because Akira was out here prior in August. And she wasn't, she was stealing from my house, so she had to go back to Arkansas. She decided to leave her own child in Arkansas and travel down here to Texas.
And what date?
And that-
Santiago did that.
That was around his birthday, like in July.
But you just said August.
No, you asked when this incident occurred.
No, I said, where was the 18-month-old in August? You said Arkansas. And you
Right.
said that Miss Santiago.
But she had been out here this whole time. Why are we talking about Akira? We're talking
I'm
about,
talking about the children. Mr. Connor.
okay, Akira, Carl, Akira's mom wasn't allowing Carl to see the children. I am in school. My funds are very, very limited right now. I don't have a lawyer to go up there and deal with that. I'm focused on being able to provide a stable
That's not
environment.
what I
Okay,
think.
so this, understanding the scenario, ma'am, to understand these direct questions of why the child wasn't there, you have to understand the whole picture. You can't just pinpoint one thing to understand a scenario that has been taking place over 2 years.
Yes, ma'am. However, my question was not why, it was where. So you have sufficiently answered that. Thank you. And so this second child, right, that's approximately 1 month old, were you aware that Miss Santiago was pregnant with that second child?
Yeah, I helped her get out of jail, so she wouldn't be pregnant in jail.
No further questions for this witness, Judge.
Nothing further, Judge.
All right, thank you.
Mhm.
Now we call, Mr. Robinson.
Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
My name is Carl Robinson.
All right, you may proceed.
Mr. Robinson, can you, tell the court why you think you should get deferred adjudication in this case?
Of course. I could mitigate a couple vast scope of factors, but specifically what I would like to proclaim is what is I have. Let me start in this minute.
Oh, take your time. You don't have to rush through it.
When individuals proclamate or promulgate that they have changed, it is usually that of futuristic, that I'm going to change and I'm gonna do this to change it. And what I proclamate is that I have, it's more than external, it's that of internal. It's that of a genuine disappreciation for the nescience that transpires within the masses.
Do you want to take a moment to collect your thoughts? If you want to do that, we can do that. Here's the thing. I want you to present the information to me that you want to present to me and the way that you want to present it. So I'm not going anywhere. I'll be here. If you need a moment to collect your thoughts with your attorney, I'm fine with you doing that, okay?
If you want to.
Yeah. So let me give him a chance to collect his thoughts with your attorney, then you can come back, okay? Okay. All right, who's next?
I have Keith Mosley.
Keith Mosley Thompson. Well, is that?
I
the-
have to swear in for the interpreter.
All right, if y'all will step back, let me take up the interpreter first because they can only be here for a little bit.
Okay,
So-
so Judge, they gave me a plea for the interpreter and I just got to it right now. I have to print out documents.
Yeah, I was gonna let you know that I was here. And
Thank
then
you.
also another. Incident.
Okay. All right, what is need to happen with your person that you have an interpreter for?
Speak Spanish.
No, I mean, what are you approaching for?
We have an MTR, we're gonna discuss with the client.
Okay, all right. So if you'll do that, then I'll take up Thompson. All right, let's go. We're juggling balls today.
Okay.
They're there, yeah.
Carl Robinson, this Michael stuff. I'll look at him.
All right, is there a application?
Yes, Your Honor. We missed them in both?
Yeah. All right, the court is calling 2025 CR 013364, State versus Keith Thompson. Can I have parties announced?
State,
Eric DeWalt, and I represent Mr. Keith Thompson.
And are you Mr. Thompson? All right, I'm gonna need you to speak up so I can hear and the court reporter can hear.
Yes, ma'am.
Counsel, you received all discovery. Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Thompson, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am, I did.
All right, did you review the true bill of indictment with your attorney? Did you understand it? Also, do you waive the reading?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
no, your Honor, state moves to waive count 1 and proceed solely on count 2.
Any objection?
No, Your Honor.
Mr. Thompson, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am, I did.
All right, you're charged with possession of a controlled substance, penalty group 1, 4 to 200 grams as a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Thompson, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, I did.
According to the plea, state is proceeding on count 2. Punishment is to be assessed at 6 years in the prison. There's a $1,200 fine. State recommends community supervision. They're taking in consideration 2025 CR 013362 and 2026 PF 13998. Did you understand that to be the plea?
Yes, ma'am.
Defense of the state? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, I did.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, any such motions?
No.
Outside the agreement, the state is requesting that your community supervision be for a term of 6 years, that there be a TAP evaluation, 120 hours community service restitution, regular random UAs, DOEP, and a referral to felony drug court. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
All right, and for the record, that's to count 2. State any evidence.
Yes, Your Honor, state offers states exhibit 1 and all attachments.
No objections, Judge. It's admittance, Your Honor. We've reviewed it.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Please, Your Honor.
Anything you wish to say on behalf of your client?
Just, Your Honor, he's been upfront and honest with me so far. He understands the plea bargain and asks that you follow the state's recommendation, please.
All right, this location you were residing, do you know the person Paul Ibanez?
No, no,
Destiny Carrero,
no, ma'am.
Aiden Aldaca, Gabriel Lar.
No, yes.
Okay, how do you know Gabriel?
He's helping me get my mom out of jail on bond.
Okay, your mom,
That's it.
your mom in custody?
She was at the time, yes, on, it was failure.
child abandonment from my little sister about maybe 35 years ago. When her, my stepdad split up, she sent to live with her grandma, they didn't let her see her. And she got hit with child abandonment, so it came back last year, or the year before. And he was gonna help me get her out, because I couldn't, because I never had, so I couldn't get her out of jail, and he couldn't.
Okay, and how long have you been using? And when did it start, really?
When did it start? When I was 28, when I lost my job, I mean, for a while. I don't got the lab tech, I was working for trials. And someone just introduced me to it, and I tried it, and it became there.
Yeah, sometimes that's the way it happens. Somebody introduces you to it. I really hope that things will change in regards to that. Because sometimes you take it once and then
You hurt, I actually stopped, don't ever rest, I quit it already.
so do you have any children?
No.
So if you're released, who would you be living with?
My roommate, George Satcher, who's been pretty much my only friend through this whole process. Except when I was using, he was against that, that's why I got kicked out of there.
Okay.
And the sport just went straight up.
Is it kind of a friend and landlord, right?
Yeah.
All right, this is what the court is gonna do. There's a $1,200 fine that will be probated. Sentence you to 6 years in the prison, suspended and probated for 5 years. Regular reporting by Zoom or in person. You need me to stop sending?
No.
You need a cough drop?
I've got one.
You need any water?
I do have some water. Let me get that.
I think they're gonna find out that maybe there's something wrong with this building. Regular random UAs. There's gonna be a referral to felony drug court. Now, I can tell you, I'm gonna have that done in custody, but felony drug court will be able to see you this week. So I'm gonna get it today. I'm gonna sign it today. They'll see you this week. So referral to felony drug court in custody, a TAP evaluation out of custody, follow Rex. If it recommends inpatient treatment, we'll start with intensive outpatient treatment. Taking consideration 2025 CR 013362 and 2026 PF 13998. There's to be no contact with the following parties. Polybanez, YBANEZ. Destiny. Carrero. Shear, SCHERRER. Aiden Aldaco. ALDACO. Gabriel Laura. There's to be no residing in households with minors. No unsupervised contact with minors. Field visits 1 time per month for 8 months. 120 hours of community service restitution. The court will deduct 1 hour for every sober support meeting that's completed. Proof of employment within 45 days of release, no employment as a home health care provider or with minors. Probation, is there anything else? Is there anything else you need from the court to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Right.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question on what that is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. So here's the thing. I know you're anxious to get out of jail, get back on with your life. You made promises to yourself that I'm never going to use again. I'm not going to do this again. You need to hold on to that and don't get caught in this backsliding. Because if you are on the path where you're doing sober support meetings, if you end up missing one, then you'll look up and you will have missed 30. All right. So don't say, you know what, I'll just do 2 the next day, or I'll just do that, because then you look up and you're off the path, and you need to remain on the path. Otherwise, you're not going to be able to get a control of your addictions, okay? All right, good luck to you. You're welcome.
Thank you, Your Honor, for our consideration. May we be excused?
Yes,
Appreciate everything.
you're welcome.
On the first row, sir, have a seat in the first row.
Reset whenever you're ready.
Do you all have the person who has the interpreter?
There's still
Yeah.
possible.
Oh, well.
No, I mean for the plea.
Which one, please? Which one?
Joseph.
No, they need an interpreter as well for the reason.
No, do we have the interpreter for the plea ready? That's what I want to know. Is the plea ready?
Not yet.
Okay. Michael, you ready?
Yes, we are.
All right.
We don't
Hi.
need an interpreter.
Yes, come on down. Lauren, we're gonna go back on the record. Are you ready on Carl Robinson? All right, we're back on the record in 2025 CR 012572-02. Carl Michael Robinson. Can I have parties reannounced?
That's for the state.
Michael DeLeon for Mr. Robinson.
All right, Mr. Robinson, you're still under oath, and did you have a chance to think about what you wanted to tell the court?
I did.
All right, do you need any more time?
No.
All right, Mr. DeLeon, you may proceed.
Can you tell the court why you think you should get deferred adjudication?
Certainly, requesting a chance of external rehabilitation. That's it. Have an opportunity to be there for my children, all the women depended on me, and then, you know, and evolve. You know, it is kind of limited, if I may evolve in such circumstances. Yeah. I have and did. But simply asking that of you understand that I have a very small record, if not minimal, you know, that of a misdemeanor. And I just feel as if I would proclaim that I qualified and deserve such chance to prove myself to myself and to my family. Then again, to be there for my children.
Mr. Robinson, let me ask you this. Do you feel like you can meet the qualification, do everything probation tells you to do if you're placed on probation?
Certainly.
And you want to have, you have an infant, you have an 18-month-old child, you want to take care of them, work, be responsible for them, help provide for them.
Yes.
Okay, you said previously, you said that you're only, I think, the only adjudication of a crime is a fail to ID misdemeanor, correct?
Correct. Sir.
Okay, you've never been convicted of a felony in this state or any other.
Correct.
Okay, and if the court places you on deferred adjudication, you and I have had this discussion. If you're placed on deferred and you do not meet the requirements of your deferred adjudication, you can be brought back to court and face anywhere between 2 up to 20 years in prison. Do you understand that?
Yes, sir.
So if the court gives you that one chance, you understand that if you mess it up, you could be facing 20 years, correct?
Completely comprehensive.
Okay. Anything else you want the court to know?
I will evolve.
When you say you will evolve, does that mean you're gonna become a better person? And
In retrospect, in knowledge and character, and in retrospect, so I will evolve generally. And I have evolved therefrom, but I am subject to inevitable evolution.
And, so I have for you, sir, I'll pass the witness.
Hello, Mr. Robinson. My name is Lauren Espinoza and I represent the state. I just have a few questions for you, okay?
Yes, ma'am.
Okay, so you told the PSI officer you came to San Antonio in August of 2025, correct?
That is correct.
Do you remember the day?
I do not, and actually, that is incorrect. I said I came in July, a couple weeks before, if you were to see the PSI, I said I was sick, but
So would it surprise you to learn that in the PSI narrative, it says August? So is that incorrect then, I guess is the question?
I guess that was improperly documented. I got incarcerated on August 9th,
Okay,
or August 8th, one of those days. And yes, I was here a couple weeks before, almost a month. So July is
okay, so you came to San Antonio in July then,
somewhere
Okay.
around that time.
and you were living with your mom for a bit, right?
Correct.
And then where were you living after you stopped residing with your mom?
I was residing hotel to hotel.
Do you recall the names of the hotels?
I do not.
Did the hotel by the name of Best Value Inn sound familiar?
No,
Okay, so approximately August 2nd, 2025, you weren't staying at the Best Value Inn with Miss Santiago?
I do not recall.
Would it surprise you to learn that she rented 2 hotel rooms at that hotel?
It would.
It would surprise you. So it would also be surprising to you that you were seen on surveillance video with her going from room 222 to room 218?
Well, I would have to, I don't know what exact hotel this is, so I don't know exactly what you're specifying. But I understand that this is dehorsed that to this specific litigation. You're not talking about this transpired.
It's an incident on August 2nd.
Right, this is not the date of August 8th, therefore it is
Right, but
unsubstantial within
you're-
objectivity, correct?
But you're aware that you were alleged to be a suspect of a robbery of a similar nature on August 2nd
Alright.
with Miss Santiago.
Judge, I'm gonna object to the question at this point for the purposes of sentencing, only because he has pled no contest to the substantiated facts that are in the PSI. I don't see the relevance of the questioning for the purposes of sentencing.
Your Honor, the offense report regarding him being a suspect on August 2nd was included in the stipulations, and it does show that he had a firearm and was participating in the same not continuous, but the same course of conduct as the instant offense here, August 9th, 2025.
Right, so here's my question. The questions that you are asking him to commit to, are those for a different offense or this offense?
It's for an incident on August 2nd. That mirrors the exact fact pattern as the August 9th offense that he pled no contest to.
He's not charged with any type of crime for August 2nd, so I don't find that relevant. Plus, this is stipulations. He has stipulated to this, Your Honor.
All right. With regards to relevancy, that's gonna be overruled. However, I don't know if your client is intending to exercise any rights related to that question. Oh,
Okay, so the instant offense here, August 9th, 2025. Do you recall being at a Best Western Plus?
This is accurate
Yeah, on IH10, right? And you were there with whom?
with the mother of my children, Akira Santiago.
Okay, and do you recall being inside the hotel room when the alleged individual complainant came into the room?
Yes,
Okay, now I want to ask you, we found out a little bit about you, right? You have 2 children. Were you thinking of your children on August 9th, 2025?
Object argumentative, Your Honor.
overrule.
You can answer the question.
was I thinking of my children on this specific date of said transpirance was the question. Yes,
Okay, and did you consider how your actions might affect your children? Or I guess child, you had a 10-month-old.
I could have pondered furthermore.
Okay, so it's your testimony to, or I guess, let me retract that. You are asking the court to grant deferred adjudication, correct?
Correct, ma'am.
What steps are you going to take to better yourself? Or what steps have you taken?
It is an internal switch in which I probably is just that of not partaking in ignorance, if I may, subjecting myself to studies, sophisticating my characteristic rather than again subjecting to the nescience. That of we have 8 hours to be out within this predicament I am subjected to. And I have completely inverted my schedule just to stay up, to study all night, and divert from things that are irrelevant. Such things that is, those are substantial steps, if you ask me. You know, that of studying, that of planning.
Okay, so if you were to be granted probation, you plan to reside with your mother, correct?
Correct,
Which is someone you were living with before, correct?
correct,
And you plan to co-parent with Miss Santiago, correct?
correct.
So how can you be sure you're not going to revert to old habits?
Well, thy will shall be done, and my will is certainly not retroactive transpirances.
And Mr. Robinson, how did you obtain the firearm allegedly used in this offense?
Object to relevance at this point, Judge. It's part of the stipulations.
All right, that will be overruled.
That's the question.
Private cell. That is state.
Private sale?
Yes, a private cell.
Was that in here or in Arkansas?
That was in Texas.
No further questions, Judge.
No further questions, Judge.
All right, I have some questions.
Okay.
And maybe the attorneys can ask it. Number one is, why are people continuing to have children and they don't have their life together?
I can't answer that for you, Judge.
And then number two, I will say this, with regards to this case, nobody has clean hands. It just depends on whether or not the public will be safe with his having probation. And based upon what I'm reading in the stipulations, I have some issues with giving him probation, and maybe somebody can alleviate my concerns, maybe not. Here are my issues. You have the complainant who meets the mother of your child, and they're supposed to be meeting up some hotel to engage in certain intimacies in exchange for funds. And according to the stipulations, this was all planned out for you to come in and take money. And a gun is pulled on the guy. You want his gold chain. And in the stips, he said you even brought the equipment to determine the clarity of the gold chain. And he did tell the guy, hey, no, I'm not going to shoot you, but I will beat you with this gun. So I don't know if anybody wants to address those for the court, because I find it very concerning as far as it relates to public safety. And I don't know if anyone is able to address those concerns. And I know that the co-defendant, the mother of your children, is in Arkansas. She ended up in probation, and I know, but for her, this probably would have never happened, because if she wouldn't agree to meet up with him at a hotel, you know, to have intimacies with him instead of you all getting a real job and taking care of the children that y'all decided to birth into this world, we wouldn't be here. So anybody want to address my
Judge-
concerns or issues?
Judge, I will address with essentially my closing argument is that Mr. Robinson's 21 years old. Young men make stupid choices. And stupid choices were made in this particular case. However, he has never been convicted of a felony before. He's been convicted of fail to ID one time in some other jurisdiction. He wants that opportunity for deferred adjudication, Your Honor, to prove himself. If he messes up, he is facing 20 years. That will ensure the community that, of public safety in this particular case. I don't know if does your brother still live in Arkansas?
No, my mom
Sure.
stays here.
Okay. Regardless, Judge, with a co-defendant who got 5 years, a complainant who got his gold chain back, a complainant who was outdoing, illicit things. Regardless, he wants that opportunity for deferred adjudication. If he messes up, he's gonna be back here. He's gonna get 20 years, up to 20 years under a deferred adjudication. We want that opportunity for him. Like most people, 21-year-old man placed in this position by themselves because of poor choices. He knows that, he gets slapped in the face with the reality of the criminal justice system. He has that one more opportunity, Your Honor, if the court provides him with deferred adjudication, provides him that opportunity to do right, to change his life around. If he doesn't, then he's facing up to 20 years at that point. So we'd ask the court to consider the fact that he has not been adjudicated on any other cases. And in this particular case, even when in the steps, he says, I'm not gonna shoot you, but,
I'll beat you.
I'm paraphrasing and,
I mean, what are you shaking your head for? That's what's in the stipulations.
That is what the witness proclamated, Ms. Boyd, but that is not.
All right, this is what I'm gonna ask you to do for me. Stop using words that have more than 3 syllables that are in no way related to the questions that are being asked of you. So here's the thing. What's in the stipulation is what I go by, because stipulated means, everybody agrees. If this person were to come into court to testify, they're going to say exactly what's in the stipulation. That's when people sign off on this, that's what they're saying. They're saying, you know what? If this witness comes in, they're going to say exactly what's in the stipulations. And when I review the stipulations, I'm viewing it to see whether the evidence is sufficient enough to find somebody guilty beyond a reasonable doubt, right? That's what the stipulations are. And obviously we're here at sentencing, so I have deemed that there's enough evidence that has been presented by the state through way of stipulation for you to be found guilty. So that's what's in the stips that I read. If that's not what I read in the stips, somebody correct me. I'm not going to take offense.
That is what is in the stipulation.
All right.
nothing further, Judge.
State.
Your Honor, we ask that you deny the application for deferred adjudication sentenced to a cap of 6 years in the prison. Defense counsel points to the co-defendant getting 5 years deferred adjudication. However, it was Mr. Robinson that had the firearm and held the complainant at gunpoint. Further, the state would assert that Mr. Robinson does pose a potential risk of flight. Based on the PSI, he does have the 3 fail to appears in Arkansas. For June and July of 2025, which were dates prior to this and shortly before Mr. Robinson did show up in Texas, as he told the court. It's actually July of 2025, not August. So he does pose that risk of flight, and I don't think he would be a good candidate for deferred adjudication. He poses a risk to the community, Judge. We can't have people in our community going around holding people at gunpoint instead of getting jobs to financially support themselves in that way. So for that, we'd ask that you deny his application.
And lastly, Judge, on the court dates in Arkansas in July or wherever, it's all hearsay. We don't know exactly when those court dates are. We don't know anything about whether he was supposed to appear or not appear. If there's a non-appearance docket, we know nothing about that. So a little nitpicky on the state's interpretation of those dates, but the main big picture is this young man has never been convicted of a felony before. We're asking for deferred adjudication, Your Honor.
All right, so this is what I can tell everybody. He's going to be convicted of a felony today. So I'm not going to grant your application for deferred adjudication. Now, whether or not I give you probation or not, that's something I still need to think about. So I'm going to find him guilty And then, counsel, you're available to come back tomorrow by Zoom?
I'll be here.
All right,
I'll be
you'll
in
be
the
here?
courtroom on a different matter, Your Honor.
All right, so the court is going to find you guilty. I'm not going to grant your application for deferred adjudication. And I'll come back tomorrow and let you know whether or not I'll grant probation.
Thank you, Your Honor.
Thank you.
Thank you.
All right, Rhonda. He's to come back tomorrow. All right, who is here with the interpreter? Are we ready? Thank you. Is this an application?
No, it is not, it's a tour.
All right, Joseph?
It is a probation.
Okay,
It's a reduction to misdemeanor.
okay. Hello. All right, court is calling 2025 CR 015212 State versus Jetsen Joseph. Could I have parties announced?
Sandra Gonzalez for the state.
Brenda La Paz for Ms. Joseph.
And are you Miss Joseph?
Yes.
All right, we have an interpreter here. If you could raise your right hand for me, please. Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Lupita Buitron.
All right, counsel, do you speak Spanish?
Yes, Your Honor.
And do you speak it fluently?
Yes, Your Honor.
And were you able to review the documents that are in English with your client in Spanish?
Yes, Your Honor.
Ms. Joseph, were the documents explained to you in Spanish?
Yes.
All right, counsel, you received all discovery. Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Joseph, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Lesser included, driving while intoxicated, 0.15 or above.
No objection, Your Honor.
All right, did you review the court admonishments with your attorney? Did you understand it?
Yes.
All right, the state is proceeding on the lesser included offense of DWI as a Class A misdemeanor. The range of punishment is up to 1 year in the Bexar County Jail and up to a $4,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
She does, Your Honor.
Do you believe she's currently competent and is legally sane at the time of the offense?
Yes, Your Honor.
Ms. Joseph, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No. No.
Anyone promise you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
If you're not a citizen, you could be deported, denied naturalization, and re-entry by entering into this plea. Do you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, state is proceeding on the lesser included offense. They're asking that your punishment be assessed at 1 year in the Bear County Jail, $800 fine probated. State recommends community supervision. Did you understand that to be your plea?
Yes.
State?
Yes, Your Honor, we don't proceed to the one.
No, is that the plea?
I'm sorry, yes.
Defense?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? And sign it in both places?
Yes.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Any such motions?
No motion, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 2 years. There'll be a TAP evaluation, 80 hours of community service restitution, ignition interlock for half the term, VIP live, DWI education course, driver's license suspension for half the term, and parenting class. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to the lesser included offense, how do you plead guilty, not guilty, or no contest?
No contest.
State any evidence.
We offer states exhibit one of the attachments.
No objection, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in both places?
I'm sorry, the interpreter have a repeat.
All right. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Part of our negotiations, she was to complete the DW education and an impact panel prior to our taking this. So she has that ready to show to probation. The rest of it, I think she is manageable. I did discuss this with the state this morning or today. She is in a study, one of those like monitor you for different things. That's going to start tomorrow. There's only going to be 2 instances where she's going to be in a facility for 10 days. One of those happens to be tomorrow. I discussed that with the state. I think she'll have her phone with her. I don't think anything should interfere with that. Oh, we did, Your Honor, talk about, she does have ignition lock on her phone right now. We did talk about the possibility of the track watch, which is new to me. It's something that's an alternative, just so she doesn't miss any load times if she's in one of those places.
All right, the court is going to sentence you to 1 year in the Bear County Jail, suspended and probated for 2 years, regular reporting by Zoom or in person, regular random UAs, $800 fine, probated, 80 hours of community service restitution. I'm going to order parenting classes. 40 hours will be deducted upon completion of parenting classes. 1 hour for every sober support meeting completed will be deducted. VIP live, DWI education course, ignition interlock for half the term or other portable device. There's to be no driving without ignition interlock. TAP evaluation out of custody. Follow recommendations. If TAP recommends inpatient treatment, start with intensive outpatient treatment. Field visits 1 time per month for 8 months. Proof of employment within 45 days, no employment as a home health care provider or with minors. Uh, Probation, is there anything else?
What about the driver's license?
Oh, thank you. There is to be 1 year. Are you all asking for a year driver's license suspension?
It's half the term, Your Honor.
That's a year.
Well, on that note, Your Honor, she did have a 3-month suspension, so that she should be giving credit for that, and then I will prepare an occupational license, bring that back. to the-
All right, I'm not gonna give credit for that. There'll be a 1 year driver's license suspension. Probation, anything else?
No, Judge.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, and I'm assuming I don't need to go over with you what could have happened if you're intoxicated, you're driving with a child in the car, anything can go wrong. You understand? So what you need to do is you need to start, well, one, since you're on probation, you're not allowed to drink at all while you're on probation. But after this probation is completed, don't drink. You understand? All right, good luck to you.
Thank you, Your Honor. Maybe she.
You're welcome. Yes. Who's next? Who else needs the interpreter?
I didn't,
All right, and who is your case?
we're ready.
All right, is this a motion to revoke?
It is.
No, I don't have Diamond Garza.
I do not have Diamond Garden's Spear Judge.
Sort of feel.
Garcia.
There it is. Did I?
All right, Diamond Garza. Oh, it's Garcia, Diamond Garcia. Hello. All right, the court is calling 2024 CR 008365 State versus Diamond Ashley Garza. I'm sorry, Garcia.
Sorry.
Yeah, can I have, now that's in my head, Kelly.
I know.
All right, can I have parties announced for the record?
Ms. Andrews Ellis for the state.
And Kelly Piddle for Miss Garcia.
And are you Miss Garcia?
Yes, ma'am.
All right, we have an interpreter and you're still under oath to the interpreter, but would you state your name for the record?
Lupita Buitron.
All right. Mr. Piddle, do you speak Spanish fluently?
I don't, Judge.
All right, and have you used the interpreter to interpret all of the documents?
We have.
All right. Ms. Garcia, all of the documents are in English. Will those documents explain to you in Spanish?
Yes, ma'am.
Well, so here's the thing.
Gotta speak Spanish.
I don't know a lot of Spanish, but I know yes, ma'am is not how you say it in Spanish. So you're either gonna speak in Spanish or not. So do you prefer speaking in Spanish or English?
I'd rather speak English.
All right. There we go.
Thank you, Your Honor.
Thank you.
Okay.
See, you have to ask, right?
Yes, ma'am.
All right. Did you review the motion to enter adjudication of guilt with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Diamond Ashley Garcia who was placed on deferred adjudication in 2024 CR 008365 for the offense of possession of a controlled substance, penalty group 1, 1 to 4 grams on September 26, 2024 for a period of 4 years? Is that you?
Yes, ma'am.
All right, state.
We're here in a violation of condition number 4 in Bexar County, Texas. The defendant Diamond Ashley Garcia did then and there fail to report to the supervision officer as directed for the months of September 2025 and October 2025 in violation of condition number 4.
How do you plead to that? True or not true?
Sure.
State.
So we have an agreed recommendation.
Well,
here.
no. Are you waiving the other allegation?
Yes, we'll waive and abandon the remaining allegations.
No objection.
All right, did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison? And up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 4? I'm sorry?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Yes, Your Honor, our proposed agreement is to grant the motion to revoke, adjudicate her guilty and put it into 2 years to.
That's our understanding of the agreed recommendation.
All right, and are you all in agreement with that?
Yes.
All right, are you asking the court to follow that agreement?
Yes.
Are you waiving your right to appeal? And that is why everyone, I check the boxes. I don't have other people checking boxes because I get to decide whether or not you have the right to appeal.
Sorry, Judge.
It's okay. All right, the court is gonna follow your agreement. The court will grant the motion, find you guilty, revoke. Court will sentence you to 2 years in the prison. Give you credit for any time served. Court will recommend the therapeutic community. Therapeutic community doesn't increase the time that you're in custody. It's really designed to help you with any addictions you may have or mental health issues that you may have. There's to be no residing in households with minors. And no unsupervised contact with minors. And just let me see something here. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing, you got to make better choices, okay?
Yes, ma'am.
When you're released from custody, there are plenty of places that will take you in. I would suggest humbly that you try to get into lifetime recovery because they will handle dual diagnosis, or, and the alternative, if you go to felony drug court will give you different resources, okay?
Yes, ma'am.
All right, good luck to you, all right?
Thank you, ma'am.
You're welcome. Have a
Have
good
a
one.
safe.
Thank you, you too. All right. And Norma, are the people I'm supposed to swear in here yet?
They're still waiting for family members to arrive, so they're outside the front.
All right. Renee, did you need to speak to me about?
Yes, Your Honor.
Yes. Yes.
Yes. Regarding Juan Jordan, he's the one, we have a spot for him at Lifetime GPS. I'm requesting GPS through the work release. Just so we can expedite. I know you wanted a tracking only, so I put there tracking only.
Yeah, I guess you're.
Thank you.
Thank you. Thanks for your patience.
Of course.
All right, who is here on Antonio Carrizales? Corrales? I keep trying to add extra syllables. Corrales. Keep adding a lot of syllables. All right, court is calling 2025 CR 011456, State versus Antonio Valentin Corrales. Could I have the parties announced for the record?
Juan Espinoza for the state.
Carl Alexander for Mr. Corrales.
And are you Mr. Corrales?
Yes, ma'am.
Counsel, you received all discovery. Did you review it with your client?
To the best of my knowledge, the state has complied with 3914 judge, and yes, I have reviewed the evidence of my client.
Ms. Corrales, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it and sign it?
Yes, ma'am. I reviewed it.
Did you review the true bill of indictment with your attorney? Did you understand it?
Understood.
Counsel, do you waive the reading?
Yes, Your Honor.
Are you proceeding as on the indictment as presented? Yes, you are.
Okay, yes, Judge.
Ms. Corrales, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am, I signed.
You're charged with aggravated assault with a deadly weapon. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call them, the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
I agree.
Did you understand, if the court grants your application for deferred adjudication, if for any reason your deferred adjudication were revoked, court could find you guilty and sentence you up to 20 years in prison and up to $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe so. I will add, he was evaluated for competency. Mr. Corrales is intellectually disabled. We did have a judicial determination that he is competent to stand trial.
Okay. And do you believe he was sane at the time of the offense?
I believe he, yes, meets the legal definition to have been sane at the time of the offense. Yes, Your Honor.
Mr. Morales, has anyone threatened you or placed you in fear to get you to enter this plea?
No,
Anyone promise you anything other than your plea bargain agreement that you've reached?
no, ma'am.
Are you satisfied with the way you've been represented?
Yes, I'm satisfied.
If you're not a US citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
I understand that.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, I read it all. I understand it, ma'am.
According to the plea, there's a $1,000 fine, affirmative finding of deadly weapon. State recommends deferred adjudication. They're taking in consideration 2025 AL 003247. Did you understand that to be your plea?
Understood.
Defense and state.
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Understand.
Any such motions?
There were only bond motions, Judge, so.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 10 years. There be a TAP evaluation, 200 hours of community service restitution, the mixed supervision, no possession of firearms, MRT, and the hostility management course. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor, state offers states exhibit 1 in all attachments.
Excuse me, we have reviewed the same, no objections.
All right, did you review the waiver and stipulations with your attorney? Oh, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine any witnesses the state would call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
I understand that.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing state's exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor, and I do have a few items to address before the.
Yes.
So first and foremost, I guess I had been dealing with Ms. Galloway. She's not present. I did submit these documents to her earlier, but I'd like the court to consider them. So they've been marked as Defendant's Exhibit 1 and Defendant's Exhibit 2. Defendant's Exhibit 1 is a disability determination explanation that was used in ascertaining whether or not Mr. Corrales qualified as being disabled for purposes of Social Security disability insurance. And then State's Exhibit 2 is that actual determination as well, showing that he has been in fact labeled as disabled by the U.S. government. As I mentioned before, and which you'll find in those, is Mr. Corrales is intellectually disabled. He's also been diagnosed as schizophrenic, as well as suffering from ADHD. There were a couple of items I did want to address in the STIPs, and the court deciding whether or not to go along with the plea bargain number 1, but also in how long the probation would be for. And that's where Ms. Galloway and I kind of were at an impasse, is how long the term should be. We're asking for something less. The state is asking for the maximum period of supervision possible. We're asking for something less. This is not an instance in which we have a thug who just runs around shooting people. Mr. Corrales, because of his disabilities, does not have the same ability to engage in decision-making that you or I have. In fact, his parents, who are present here actually, have been awarded guardianship over him by a court. When Mr. Corrales turned 18, he was residing in the state of Utah. Courts there felt that he could not take care of himself or make decisions for himself, and therefore his parents were appointed guardians over his person and estate. They went on a vacation and left him alone when this happened. They are committed to supervising him, making sure that he succeeds. They have been monitoring him ever since he has been out on bond for this. They are the ones that actually retained my services, as Mr. Corrales himself really only has his Social Security income that he gets. So actually, I'm going to ask you to probate the fine as well. But in the reports, Judge, there's some things that I think on paper look bad that bear explanation. One, Antonio, as a young man, actually managed to become an Eagle Scout. He did engage in shooting sports, and one of the things he was taught to do, and that's ingrained in him, is that you pick up your brass. I know the detective went out of his way to point out about how Antonio picked up the shell casing. So that explains that. The detective also writes that Antonio walked out of the location. Discussing that with Ms. Galloway, and she agrees with me. The video shows a different story. And it's talked about a little bit in the press guide. A witness by the name of Michael actually engaged in a physical altercation with Antonio. And it was Michael that forced Antonio to leave. So it wasn't that it was a cold-hearted, just I shot someone and I'm departing. Antonio was forced to leave, Judge. And so I think that makes a difference when we're evaluating cases like this. Antonio needs help. He needs to be in the MIC unit. He needs supervision. He needs the kind of help that unit can provide and that his parents are committed to helping him with. The court may remember during the pendency of this case, he was also hospitalized for his mental health and actually missed court, and we had to provide proof of that. He has had some suicide attempts in the past. He has engaged in some self-harm, and a lot of that is actually talked about in the narrative portion of Defendant's Exhibit 1. My concern with what the state wants with 10 years of deferred is that long of a period with a young man who has the deficits that Antonio has, is we are exponentially increasing the likelihood that he will mess up on some sort of technicality. The court can certainly extend him if he has a minor violation. And obviously, and I had to explain it to him a few times, but he understands that if he were to violate, the court also has the full range of punishment if the court chooses to revoke the deferred adjudication. but we're asking that you at least start him off somewhere on the lower end of 3 to 5 years, which I think is certainly enough time to see how he does, to see if he is rehabilitated, if he has learned from what he did. And if he needs a little more time, then the court, of course, can always extend him up to the 10 years. But I think the 10 years, when you look at the totality of who he is and how this all came to be, I think 10 years is excessive.
All right. I'm gonna allow defense counsel to withdraw defense exhibits 1 and 2.
Thank
And
you,
if
Your Honor.
you'll give those to probation.
Yes, ma'am.
This is what the court is gonna do. Court is gonna sentence you to $1,000 fine that will be probated. Regular reporting by Zoom or in person, regular random UAs. Is he going to remain in San Antonio?
Believe so.
Yes,
Yes,
ma'am.
yes, his parents are nodding yes.
All right, take in consideration 2025 AL 003247, 6 years deferred adjudication, no contact with the complainant, no possession of firearms or ammunition. There will be a referral to Center for Healthcare Services, the Mental Health Initiative, 200 hours community service restitution. Once he's completed hostility management course, 100 hours will be deducted. The remaining 100 hours will be deducted upon completion of the MRT. Proof of SSI or proof of employment within 45 days. No employment as a home health care provider with or with minors. Are there any minors living in the household?
I don't believe so.
No,
Yeah, okay. There's to be no unsupervised contact with minors. No residing in households with minors. No contact with the Waterburger that's located at 8002 Fredericksburg Road. And field visits 1 time per month for 8 months. Probation, is there anything else?
No, good.
All right, is there anything else that you need from the court to be successful?
just, I wanna be an electrician, so I wanna go to school.
Okay,
Let's finish your probation first. Okay.
Judge, mental health will make supervision or no?
yes, mixed supervision. All right, and I'm sorry, there's an affirmative finding of deadly weapon.
Yes, ma'am.
All right, to the parents, is there anything else he needs or they feel he needs?
Feel good?
All right. All right, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it? Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
I understand.
All right, we can go off the record. Here's the thing. Whenever there are disagreements between people, when you see it's ramping up or escalating, just walk away. In the words of my grandmother, you know what she would always do? She'd walk away and she'd say, somebody gotta have sense. And so she'd just walk away. So in your mind, you can say, somebody gotta have sense and just walk away. Okay? All right, good luck to you.
Thank you.
You're welcome. Thank you for dressing appropriately for court. You always do, though. I appreciate that.
I appreciate it.
All right, thank you.
Thank you, Jen. She may be excused.
Yes. Anyone else ready?
No, yes, I have a report.
Robert?
Page 3, 1 down.
All right. Tabler? Hello. I see it's acting as though it's doing dial-up. All right, so outstanding ballistics. So,
No, me and Miss Galloway have been fighting all afternoon. She finally made us an offer. I know today was a final offer date, but she just made the offer.
oh, no. Actually, on here, I have it, the outstanding ballistics that y'all have all.
We have everything, Judge.
Okay. Oh, you know what? It's probably listed on.
When the other one she's got,
Yeah, on the other cases. All right, so I'll give you guys a pre-deadline date. How much time are you asking for?
I don't need much time, Judge.
No, I
I
mean,
don't-
when do you want to come back?
2 weeks. 2 weeks. is fine.
All right, Norm, I need a 2-week reset for pre-deadline day.
Yes, ma'am. I can do May 11th.
May 11th? All right, so we'll be back on May 11th. At that time, you need to let me know if you've reached an agreement, okay?
Thank you, Judge.
All right, thank you.
Judge,
Yes.
sorry, just have a seat, sir. Right, Mr. Tevin, have a seat. Is there anything about film business?
Yes. Oh, I'm sorry. One time, per month for 8 months.
8 months.
Yes.
You're ready to my approach?
Sure, just give me 1 second. And Norma, if you can call David Woodard.
Yes.
Oh, that's your, yes.
Yes. Just gonna ask, what are we doing with that case?
Thank you. All right, and where is Mr. Cox?
Yes.
Thank you. This is. Well, yeah. I mean, I find people reading. Hey.
And Norma?
In the back.
That's okay. I can.
David?
I'll take a picture of it.
Okay.
Leave it if that works.
Okay, yeah.
Yes, Judge.
All right, the state, the coordinator, they think that maybe your client may be confused on her date.
Correct.
So, we will just recall it for Thursday.
Okay, Judge, I have my calendar.
All right, thank you. Like the poster behind you.
Oh, no worries.
Oh, knocking down Sunny Liston.
Have a good one.
Have a good one, Judge. Be safe.
All right, you too. Bye-bye. All right, see you tomorrow.
When he goes, that's a.
Hi.
Thank you.
And I'm doing great. How's it going? Let me know when you guys are ready. You are? All right, so is this a swearing in for law? How many people?
They have minors.
My daughter,
Mr. Wilkins?
I don't know about my son-in-law. My daughter, yes.
Okay, can you give me the full name?
Phineas? All right, Norma. The letter K, right? Norma, do you want the letter K long down? Let's go. Okay. All right, so, who are the people who helped her get to where she is today? Do y'all want to be a part of this? But why are y'all sitting back there? Come on. Oh, come. Judge Carruthers.
Yeah.
Come on up, Roxy. This done. Once this is signed, can you officially our attorney? Still gonna need all the. Take that. Oh, I did. Great answer. On. Yeah. Okay. Awesome. So I'm gonna swear you in. And I'm gonna swear you in 2 times. One, A, one without. Wait, we can just do one with. Just roll with it. All right, if you'll raise your right hand for me, please, and repeat after me. I, Via Irvin, I, Via K. Irvin, do solemnly swear that I will support the Constitution of the United States and the state of the Union. That I will honestly commit myself in the practice of law. That I will discharge my duties that are to my clients, to the best of my ability. And that I will conduct myself in that with integrity and civility in dealing and communicating with the court at all parties and all parties. So help me God. So help me God. Right, God. Still not official to stop. Oh, no. Here's the thing. You can say, you know what, I changed my mind. Or we can go for it. There's a pause there. All right, so if you guys can take a for signing, and then I'm gonna get the free thing over. So if you'll sign, everybody petition for signing. We got it. Okay, I got it. Right, so if you'll sign, yeah. All right, and then I will sign here for Jason. So as of April 7th, you are officially an attorney. Welcome. Okay. All right, then next you gotta get a picture of you. Will do some work. Okay. Take the picture off. Thank you so much. Oh, you're so welcome. Thank you. All right, yeah, awesome. So, then you need to take a picture with everybody next to James. Look like, oh, I can't make it. And give her all, see for support. All right, so everyone, let's go and get photos. Yeah. Yes. Yes, that's the document. That's the Revocation. Take big pictures of everybody. Y'all take something out. Hey, get in and I'll take it to you. Okay. Yes. Yes. Okay, Daddy, I don't wanna be in there. Let me go there. Hey, go back in there. All right, Judge. You're pretty good out, so I'm gonna sign it for you now. Just wait for the other. All right. Okay. Congratulations. Thank you. Oh, no problem. Thank you, regulator. And if you ever do anything, everybody has my cell number, so call. All right, you're welcome. Go out and celebrate. Yeah. Yeah.
It looks beautiful. Cornelius, what's happening with your case? All right.
Oh, no. Can you give this to Adriana? Yes.
I'm telling you, there's something that's been going on. All right, so let me see. Okay, actually today is jury trial setting. Okay. Oh. Okay. All right, this is what I'm going to do. Deputy Laura, Norma, oh, she went to the back. we'll just recall him, let's recall him for tomorrow and see where everybody is on it. Are you available for tomorrow? Okay, all right, we'll recall him for tomorrow. Okay. Okay. Oh, no, we'll just recall him for tomorrow to see where everyone is. Okay. Come for Mr. Keonis.
No, Jen.
All right, recall him for tomorrow.